Namaskar friends, this grant of notional increment has now become final. Early last year, government has issued orders stating it is a temporary arrangement. We have filed a review petition and all those things. But now in February 2025, Honorable Supreme Court has rejected the review petition filed by the government. Now government has issued, that is DoPT, Department of Personnel Training has issued office memorandum, number is 19/116/2024, personal policy pay part file dated 20th May 2025. I have shown the orders also on the side, and now the rules are very clear. Those who have completed 1 year before the date of retirement, that is, if somebody retires on June 30th and his increment is due, annual increment is due on July 1st, or somebody retires on December 31st and his annual increment is due on the next day, that is January 1st of the next year. So they will be eligible for one notional increment for fixing the pension, only for fixing pension, not for payment of other retirement benefits like gratuity calculation, no, this leave encashment calculation, no, all those things, nothing. It is only for fixing pension. One additional increment is given and then pension is fixed. Okay, this is a really great thing, and it has become now final, and the effective date is from 1st May 2023. That is, Supreme Court has issued orders during that time in 23. So those who have already retired also will get this particular notional increment from May 1st 2023. And those who retire later on, after 1/5/2023, suppose if they retire on June 30th, completing 1 year service for increment, yes, one increment will be added in their pay for fixing pension, and then from that date, that is from the date of retirement, they will get pension with enhanced value. Similarly, for December case also, on December 31st somebody retires on superannuation. This retirement is only for superannuation, so people should not confuse with for other retirement, number one. That is another important point. Okay, now there are certain cases, because this case is going on for the last 10 years or so, so there are some confusion how to handle those cases. Those who have filed cases and won the case prior to this one, yes, they will be paid as per the order of that judgment, whatever case, and they will get according to that. Okay. And those who have filed intervening petition, impleading petition, writ petition, original application, something like that in Central Administrative Tribunal or High Court or Supreme Court, now they need not wait for finality, because now Supreme Court has decided. So for them, this notional increment will be allowed for a maximum of 3 years from the month of filing. Suppose somebody has filed in any of the courts and case is pending, let us say, now they can withdraw because they will get the money. They did not wait for final this thing. Suppose, let us say, somebody has filed in January 23. They have retired some 5 years ago, let us say. So 3 years in advance they will get, that is 22, 21, 20. So January 21 onwards, they will get notional increment. Suppose they have filed January 23, but they retired in January 22, let us say. That 1 year they will get. 3 years they can't get, because they have retired only 1 year ago. From the date of retirement they will get, because 3 year window they get. This is for cases which are pending or whatever it is in the current status. But this filing is prior to the decision of Union of India versus M. Siddaraj. So the case was decided in April 23. If somebody files afterwards, no, that is not valid. Prior to that, if somebody has filed in any of the courts, Central Administrative Tribunal or any of the high courts or even some case in Supreme Court, I don't know whether case is there or not, they will be given maximum of earlier 3 years also if they are retired, more than 3 years before they are filing the case. But if the intervening petition or anything is filed after the Siddaraj case, then for them this 3-year window is not available. Of course, they will also come under normal rule of the effective date is from 1st May 2023. So if they have retired prior to that, yes, they will get from 1st May 2023. And if they have retired later date, of course, they will get from the date of retirement, if they are eligible, that June or December retirement date, and at the time of retirement they have completed 1 year service. This is another important case. One more important point, very minor cases may be there, that is those who were already paid based on some court case and it turns out to be excess amount. No recovery should be made. This is again special case. So this case is, suppose if the decision is taken earlier based on some court case also, and that was done prior to 20th February 2025. That day Supreme Court has rejected the review petition and their decision was in April 2023. So these cases, that is the excess amount everything paid prior to that, yes, it should not be recovered. They will be allowed with that, but of course refixation based on the new order, if any issues they can do, but no recovery will be there. Only one condition, along with the increment annual service thing, government has put retiring person must have 1 year qualifying service as on the date of superannuation with satisfactory work and good conduct for calculating this pension or enhanced pension, whatever it is. That means the condition applies is nothing but good conduct and satisfactory work. So if somebody is charged with something in the last year, there is a possibility they may lose additional notional increment. But this is only normal rider and all. But normally people who retire after completion of 1 year service from either on June 30th or December 31st, having 1 year service for increment date also, yes, they will get one increment. Now the question arises, what is the starting date for calculating all these things? Safely we can say 1/1/2016, both increment dates are there, January and July. Okay, so those who retire from 1/1/2016, yes, they are eligible for one notional increment, subject to all these conditions. What about July only? 2006 onwards, single increment date was fixed, that was July 1st. So in my view, those who retired on June 30th after 2006, after completing 1 year of service, due for increment, they should also be considered for one notional increment on the date of retirement, that is June 30th. Though it is not written in the order, in my view it is valid. Though it is not clearly written in the rule, it implies that. All the best those people who have retired on June 30th and December 31st with 1 year work without increment, because 1 year completed by that time and they did not get increment due to increment date falling next day. Yes, they can write to their department quoting this order to fix their pension again and get arrears from 1st May 2023 if they have retired prior to that. All the best. We'll see in some other videos in the coming days. Thank you.